It's a real honor to be here at the Baton Rouge Press Club today to speak about this issue, which has become a life goal for me personally. I think that if you want to know about what we need to do in Louisiana, the answer is we need to inform people about the truth of this law. I stand before you as someone who's practiced law for 38 years, and for 35 of those years had no knowledge of the origins of the non-unanimous jury verdict law in Louisiana. None whatsoever. I mean, never heard about it in law school, never heard about it at a law seminar, and never even talked to any other lawyer about it, because the story had simply been lost to history. We simply didn't know the truth. Now, there were a few people that did know the truth, and there were a few people that had been laboring in the vineyards for many years to change the non-unanimous jury verdict law and had taken appeals to the U.S. Supreme Court and had litigated this issue. But that group was a very tiny, small group of people. For the vast, overwhelming majority of the public in our state and lawyers, we simply did not know. I'll have to say this, that a friend of mine in Leesville, Louisiana, in the August of 2015, approached me on the floor of the courtroom and said, "Hey Ed, have you heard about this book that the LSU Press published talking about the Jim Crow origin of the non-unanimous jury verdict in Louisiana?" And I said, "What are you talking about?" He said, "Yes, there's a book out on it. The name of it was Jim Crow's Last Stand, the non-unanimous jury verdict law in Louisiana," published by the LSU Press in 2015, written by Dr. Thomas Aiello, a history professor at Valdosta State University in Georgia. I'll have to say, this book was a life-changing book. I bought a copy at the LSU bookstore in late August of 2015, read this book in short order, and when I finished the book, I told my wife, I said, "This law must be changed." I simply didn't know about the origins of this law, and I will do everything in my power to see that we get rid of this law. In fact, I made a decision at that point to make it a life goal that we should end the non-unanimous jury verdict in Louisiana. It was a profound moment because I realized that for decades, the people of Louisiana had not enjoyed the full protection of the right to trial by jury. That what we had in Louisiana was an aberration. It was an anomaly. It was outside of the mainstream of American legal tradition. We had been deprived of the full protection of the right to trial by jury. Reading this book started me on a journey, the journey of discovery to find out more about the history of jury trials in America, and particularly what had happened in Louisiana. My research revealed to me that the jury goes all the way back to the 12th century. The roots of the jury trial protection can be traced all the way back to the Magna Carta in England. It comes all the way through the colonial era. When the colonists came to America, they brought with them the legal tradition and the history and the understanding of what the jury trial protection meant in England. They brought that to America. And in every colony, juries were active prior to the Revolution, prior to the War of Independence, prior to the Constitution, prior to the Bill of Rights. Juries were functioning in America. Every state had a jury trial provision in its Constitution. And this is in the colonial era. The history is clear. It is absolutely clear. Unanimity is the critical and crucial part of the jury trial protection. Without unanimity, you don't have the full protection of the right to trial by jury. Why should we be concerned about it? We should be concerned about it because in our state, for 138 years, we've been deprived of this. You know, at one time, Louisiana did have unanimous juries. From 1803, from the time of the Louisiana Purchase, until 1880, for 77 years, we enjoyed unanimous jury verdicts. It wasn't until 1880, in the post-Reconstruction era, 15 years after the end of the Civil War, that the legislature voted to allow a person to be convicted with a vote of 9 out of 12 jurors. Now, it's true that it was changed in 1973, and there was an effort made in 1973 to try to change the law, but that effort failed, and a compromise was reached, and so we have the law that we have today, which is that a person can be convicted of a felony with 10 votes out of 12. We went from 9 out of 12 to 10 out of 12. Well, that really wasn't much of a change. So in essence, the law that we had in 1880 has carried down for all these 138 years, and we still have the same law today. I think when you look at where we are in Louisiana, we're at an amazing point. Look what happened this past spring in the legislature. What took place was an amazing event. For the first time in anyone's memory, no one recalls an attempt ever being made before. An effort was made to change the law. The Louisiana Criminal Defense Lawyers Association in January of this year met and decided to make changing the non-unanimous jury verdict law a priority. We sought the support of Senator J.P. Morrell and Senator Edmund Jordan, Representative Edmund Jordan here in Baton Rouge. They both agreed to write legislation which was introduced. Senator Morrell's bill was Senate Bill 243, and his bill got heard first. That hearing took place before Senate Judiciary Committee C, and that was an amazing day. What happened was, for the first time, this law was discussed and brought before a committee of the legislature. The vote was 5-1. Senator Dan Claytor is the chairman of that committee. He was firmly in support of the legislation. We were excited. We were elated. We left that committee, and someone in the hall said, "Eddie, it's only the committee. You still got a long way to go." But I believed that we could win this. And so for the next 2 weeks, the lobbying team of the LACDL, which was composed of myself, Christy Smith, an attorney from Leesville, King Alexander, an attorney from Lake Charles who's here today, Suchitra Sapathi, a young lobbyist with the Rodell Parsons law firm who was the lobbyist for the LACDL. We worked tirelessly, talking to every senator we could talk to, receiving objections, trying to overcome objections, explaining the history. And well, we come down to April 4, 2018. That was a marvelous and impressive and miraculous day. We went into the vote not having the votes. I remember distinctly standing on the side of the Senate chamber with Senator Morrell, who's here today, talking about the fact that we knew we didn't have the votes. We had about 22 or 23. But I felt like we could do it. I felt like we could do it. I had, I share this really quickly. The morning I drove to Baton Rouge with my wife, I had been praying about this, and a verse came to my mind. It says, unless God builds the house, they labor in vain, those that build it. And you know, I said to myself, I realized God has to do this. This is bigger than any of us. This has been here so long. This is a giant, and we have to slay this giant. And so when we got to the legislature that day, the chaplain, the pastor saying the prayer, opening the Senate, quoted that scripture. The very one that I had read that morning and had prayed about on the way down. And when he quoted that scripture and said the prayer, I said, all right, we're going to do this today. And sure enough, Senator Morrell gave an outstanding speech laying out the argument for why we needed to change this law. Senator Jay Luno gave a great speech. And then Senator Dan Claytor took the podium and gave what I think was probably the greatest speech of his entire political career. I wish Dan was here today. It was magnificent. And he laid out how we had been deprived of the full protection of the Sixth Amendment in Louisiana. And he was magnificent. And let me tell you what, after that speech, Senator Morrell took the floor again. He gave a great closing argument. And then Senator Lario said, open your machines. And those machines opened, and everybody stood up to see what the vote was going to be. And let me tell you what, the screen was covered in green. The board was covered in green. Wow! And then a few red votes popped up here and there. But the vote was 27-10. Wow! It was incredible. Senator Morrell, he couldn't believe it. And neither could a lot of other people. This was the moment. And when that vote was over, I knew in my heart that we could win this issue. We could win this fight. That the people of Louisiana were ready to change this law. And so what happened from there, we went to the House, and we had a House committee we had to go to. We all testified before the committee. The committee voted 14-0 endorsing Senate Bill 243. It was outstanding. And then when we went to the Louisiana House of Representatives, the vote was 84-15. 84-15. An overwhelming victory. No one could have anticipated this. This was the issue of the session. So I just want to say, what happened was incredible, but it shows you what can happen when people come together on an issue that transcends political parties. This was about liberty. This was about justice. This was about fairness. And this issue carried the day. So we get to this point. We still have work to do because we have to educate and inform the voting public. This is an issue that takes a few moments to explain. The history is important. How we got this law is important. The fact that this law came from the Jim Crow era is important. The fact that it was passed in 1880, 15 years after the Civil War, is important. 3 years after the end of Reconstruction. The history of this law is really important. The history of this law is why people labored in ignorance for so long, because they didn't know the truth. Once you know the history of the law, then you have to vote to repeal this. I'll simply say this, that what we've seen happen in the last few weeks, we have seen a groundswell of support. I would like to say that the Morning Advocate has done an incredible job of informing the public about the truth of this issue. The editorials, the analysis, the reporting that the Morning Advocate did prior to this issue. I mean, this work had been going on for 2 years, but the stories came on Easter weekend. April 1st is when the big story hit the papers. It was incredible. The analysis that was included, the data that was gathered, they showed that 40% of the jury trials in Louisiana were returning non-unanimous verdicts. That's an incredible statistic. That's a statistic that no one had. But I'll have to commend the Morning Advocate for doing the hard work that it took to dig these facts out from around the state we know that this law has made a difference in Louisiana. I have said that it hangs like a cloud over the criminal justice system in our state. It not only influences who is prosecuted, it influences how people are defended. It influences the entire criminal justice system. And you know, the conversation we're having today, they're not having in 48 other states because it's not an issue there. It's only an issue here. But thank God we're finally having the conversation after 138 years, and now the people of our state will get to choose. The people of our state will get to make a decision about what to do. We have groups that have organized. We have groups that are on the conservative side of the ledger and some that are on the liberal side of the ledger. We have people from all points of the political spectrum that have gotten involved in helping to pass Amendment Number 2. One group, Louisiana Republican Judiciary PAC, located right here in Baton Rouge. I mean, they're active, raising money. They're going to be shooting some video, engaging in some public information, a public information campaign. There's another group in New Orleans, the Unanimous Jury Coalition, which is a large group of a bunch of different organizations that have all come together to support passage of Amendment Number 2. The Promise of Justice Initiative, the Voice of the Experienced, those are some of the leading groups in that coalition. There are many, many others involved. And there are other groups being formed, and there are other groups that are going to be involved in this. I know that in the legislature we received the support of the Louisiana Catholic bishops. The Louisiana Family Forum was critical to our success. Gene Mills and his staff lobbied in the House, and I'll have to say this, that I believe that the large margin of victory that we received in the House was due in large part to the effort of Gene Mills and the Louisiana Family Forum. We had Americans for Prosperity. John Kay was actively working on this. And we had the support of the Louisiana State Bar Association. Their lobbyist was actively involved in lobbying this bill. And you know what happened as we went along through the legislative process? It was an amazing experience. I would have people come up to me and say, "Ed, I like what you're doing. Ed, I'm for this. Ed, what can I do to help you?" Or some other person would come up and say, "Hey, Ed, you know, I'm friends with so-and-so from somewhere else in the state, and, you know, I can talk to them for you." I said, "Please do." We can use all the help we can get. But so many people, and these are people that this wasn't their issue, but they saw the value of this. They saw the righteousness of it. They saw the importance of it, and they came on board to help us. Let me say that Louisiana stands at a crossroads. We as a people stand at a crossroads. Our decision will affect the lives of thousands of people. One road leads to liberty. The other road leads to a loss of liberty. Which road will our state take? For 138 years, we have endured the loss of liberty. Because with the loss of unanimity, we have endured a jury trial system which bore no resemblance to the jury which James Madison, John Adams, and Thomas Jefferson placed in the Constitution and the Bill of Rights. Let me repeat that. The jury system we have bears no resemblance to the jury system that the framers of the Constitution, Adams, Madison, Jefferson, placed in the Constitution. What we have is outside the mainstream of the American legal tradition. What we witnessed this past spring, was a remarkable coming together of people from all points of the political spectrum. People that came together for a common goal and a common purpose. Everyone embraced a shared vision of restoring a tangible aspect of constitutional liberty taken away from the people of our state 138 years ago. What happened this spring was a magnificent moment for our state, a moment that we can all be proud of, a moment that we can cherish. It was evidence that the cause of liberty transcends political parties and diverse backgrounds. It was proof that the fight for justice and fairness is a battle we can all be a part of. The unanimity of the jury embodies the essence of liberty because it guarantees that no person will be deprived of liberty unless everyone on the jury agrees. The jury decides, not the state. The jury decides, not the prosecutor. The jury decides, not the government. And who is the jury? It's the people. It's the people. The people decide. The jury stands between the people and the state. That is why Sir William Blackstone called the jury the great bulwark of liberty. And that is why John Adams said that it was the unanimity of the jury that preserves the rights of mankind. It's time for Louisiana to turn the page. It's time for Louisiana to put this relic of the Jim Crow era in the past. It's time for us to move toward the light of liberty. It's time for Louisiana to move forward to what it can be. If you support the Constitution and the Bill of Rights, you will vote for Amendment number 2. And if you love liberty and justice and fairness, you will vote for Amendment number 2. And if you love Louisiana and you believe that our best days are ahead of us, you will vote for Amendment number 2. And I believe the state will vote, and I believe it will be passed. Thank you.
All right, now we're going to take a few questions, and again, I just ask that we keep it to members of the working media and members of the press club.
Thank you, Elizabeth. Go ahead.
All right, I guess I'll go first here. So how many people do you interact with on any given basis who simply just don't realize that the non-unanimous jury law that we currently have on the books is a thing here in Louisiana?
The question is, how many people do I interact with that don't realize that we have this law on the books in Louisiana? Well, the answer is, amazingly, a lot of people. In fact, most people believe that we have the law that every other state has. The reason for that is that most people get their legal education from CSI. And on CSI, you know, one juror can result in the state failing to prove its case by reasonable doubt. It results in a hung jury. But that's not the law in Louisiana. And I've talked to a lot of people who've said, in fact, I've even talked to a few people that served on juries who went into the jury room and were told right before they went into the jury room, oh, by the way, you only need 10 votes for a conviction and not 12. And they were said, what? That's the law in Louisiana? So, you know, I think there is widespread unfamiliarity and ignorance of the law, even among lawyers. I mean, if you don't practice criminal law and if you're not involved in the criminal justice system, you don't have any reason to focus on this. So the fact is, overwhelmingly, large amounts of people simply don't know the truth about this. So that's our job. Our job is to educate the public and let them know what the history of the law is and why we need to change it.
Do you expect anyone's going to be putting up a advertising or political campaign with money behind it to defeat the ballot initiative, like in opposition to what you're trying to do?
Her question is, do I expect anyone will be putting up an organized campaign against the unanimous jury amendment and running an organized campaign to defeat it? The answer is, I don't know. I hope not. We've not seen any indication that there will be any organized opposition. I'm sure there will be opposition from people in different places, but my hope and prayer is that if we can educate the public and tell the story of how we got this law and what the impact of the law has been on the people of our state, that we can persuade enough people to vote for it. And that's what I believe will happen. But in answer to your question, I don't know that there's any organized opposition.
You haven't seen any yet?
No, we have not.
Sheriff had been asked of you before, should this law be passed, what would the effect on those already adjudicated on a 10 to 12 level?
Well, my understanding is the effect on those already adjudicated would be nil. That the law that was passed by the legislature, the legislation specifically provides that this will only affect those people charged with a crime that was committed after January the 1st, 2019. So it's prospective in effect only. It is not retroactive in its effect. Now, that was a question that was raised on the floor of the Senate. Senator Morrell had to deal with that, and we specifically made sure that there was language in the legislation that provided that it will only be prospective in its effect. Now, that's not to say that lawyers can't file writs and file motions and do whatever they want to do to try to revisit their clients' cases, but this amendment will not do that. This amendment is only prospective only. Yes, Lanny?
I wouldn't want to cast any unflattering light on our unprogressive friends in Oregon, I believe it is. But is it in fact Oregon that is different? And I think we had a story about this, but the way they apply their non-unanimous system is somewhat different from ours. Is that correct?
I think their vote is 11 out of 12 instead of 10 out of 12. I think that's one difference. There has been some movement in the state of Oregon to change their law. Earlier this year, the District Attorneys Association in Oregon had made a statement that they were considering leading an effort to change the law. There's been some back and forth in Oregon, and I haven't kept up with the recent developments, but I do know that there are discussions in the state of Oregon to change their law, and now especially in the light of what the Louisiana Legislature has done. I think a lot of people in Oregon simply don't want Oregon to be the only person out there having this terrible law. Once Louisiana changes its law, then Oregon will be all by itself. Yes, sir.
The legislative battle was tough, but how much tougher, if so, is trying to gain popular vote here? Well,
gaining the popular vote is a challenge because we have the entire state to cover. We have to meet with people. We have to get the information out to the public. Part of what the groups are going to be doing that is supporting Amendment Number 2, they will be putting up websites. There will be media on the internet, digital media. There will also be both earned and unearned media. So we're going to see a real push take place between now and November to get the message out. I mean, that's what's going to happen. I mean, I'll be speaking at a forum in West Monroe in a few months. I'll be at a meeting in Lafayette on August 22nd. I mean, I expect to speak to a number of groups all around the state. And there'll be other people speaking on this as well. And Senator Morrell, he's here today. I know he'll be speaking on this. He's already been speaking on it. Senator Dan Claytor is going to be actively involved in it. I met with Senator Claytor a few weeks ago. I know Scott Wilfong with Louisiana Republican Judiciary PAC. They're going to be working hard on this issue. And so there will be a number of legislators involved. You know, one of the most amazing things that happened was in the legislature, it was truly a bipartisan effort. If you look at what happened in the Senate, you got Senator J.P. Morrell, a Democrat, Senator Dan Claytor, a Republican, leading the charge on this issue. And then look at what happened in the House. Representative Sherman Mack from Albany, who's the chairman of the House Administrative Criminal Justice Committee, he handled the bill on the floor. And Representative Ted James, Representative Edmund Gordon, they were all involved in this. So Jordan. So we saw a true bipartisan effort take place. It was just amazing how this all came together. And I don't think at the beginning of the session anyone could have predicted this. And I know you have some reporters here, some journalists that work the session all the time, and I don't think anyone can say that they ever saw this coming. I mean, really, it's like it came out of left field, but it really didn't, because there's a lot of people that had been wanting to do this. There had been people that had been, you know, working in the vineyards for years to see this done. I know Professor Angela Allen Bell at Southern, G. Ben Cohen with the Promise of Justice Initiative has filed like 20 writs with the U.S. Supreme Court. Some others that were out there, Marjorie Essman in New Orleans. on and on and on. Many, many people had written editorials and op-ed pieces. So there was work out there by a lot of other people. We were just really blessed to be at the right place at the right time with the right message. And we had a great champion in J.P. Morrell and Dan Clater, and that got us going. Elani. Yes, sir.
Give us a 2-minute history lesson about 1880 and what actually happened.
Well, what actually happened in 1880, let me just put in another plug for this book now. I don't get any royalties on this, but this is a really good book that the LSU Press published. So if you hadn't gotten one, you need to get one. But Dr. Aiello explains it in great detail. But what happened was Reconstruction ended in 1877. The federal troops were withdrawn at that point. And the Redeemer Democrats, the white planter, merchant, lawyer aristocracy began to reinsert its control over state politics at that point. They were known as the Redeemers in history. All throughout the South, all of the Democrat governments that came back into power after Reconstruction, that was known as the Redemption, the Redeemer Democrat governments. And so those people essentially regained control of the state after Reconstruction, and the legislature had a constitutional convention in 1879. It allowed the legislature to do this. The law was changed in 1880. There's no question but that the law was changed for the specific purpose to make it easier to convict the newly freed slaves. There's no doubt about that. So there was great controversy all throughout the southern United States about the newly freed slaves serving on juries and serving in local government and state government. There was a continual battle that took place for years and years about the newly freed slaves being able to exercise the full rights of citizenship. And so what took place in 1880 was symbolic of what was happening all around the South. But only Louisiana got rid of the non-unanimous jury verdict. I mean, this didn't happen in Mississippi or Alabama or Georgia or South Carolina. None of those states got rid of the unanimous jury verdict. Only Louisiana did that. So, I mean, what happened in Louisiana was arguably worse than what happened in any other state, because we deprived everyone of the full protection of the right to trial by jury. And we have continued to deprive everyone of the full protection for 138 years. So if you look at what happened, the enormity of what took place in 1880 is arguably, as great as anything that took place, or as bad as anything that took place, maybe that's a better word, as anything in any of the other southern states. So that's what happened in 1880. Now look, it wasn't placed in the Constitution until 1898. I know a lot of stories talk about the Constitutional Convention of 1898, which that was a really, terrible constitution. There's no question about it. But it was put in the Constitution in 1898. It was first enacted in 1880. So you have to understand, by the time the Constitutional Convention of 1898 came around, we already had the law for 18 years. 18 years. And, whereas in look, Dr. Aiello talks about this in his book, but in 1880 there was a tremendous battle in the legislature about whether to let this happen. Because at that time you still had African-American legislators, you still had Republican legislators, you still had the remnants of the Reconstruction governments in place. So there was a tremendous battle that took place in the Louisiana House and the Louisiana Senate. So this did not pass in 1880 without opposition. There was great opposition from all corners of the state. But what happened in 1898, there was virtually no opposition in 1898. And by the way, that 1898 Constitution was never voted on by the people. It was just voted on by the Constitutional Convention and the legislature, and that was that. So, no, what happened in 1880 was a serious event, but you have to understand it in the light of Reconstruction. It took place in the post-Reconstruction era, and it was an evil and wicked law. There's no question about it, because it deprived people of their rights of citizenship. And it has continued to have that effect, because all of us, every person in Louisiana, has been deprived of the full protection of the right to trial by jury. So, I mean, that's I guess that's one of the ironic things about the ultimate impact of this legislation. It was designed to affect a certain specific group, yet in the end, it wound up affecting everybody. All of us were deprived of a right of citizenship when you think about it. So that's why this must be changed. This is something that is a stain on the legacy of our state, and it must be removed. It is a stain on the legacy of Louisiana. It's time for us to remove this.
When it comes to public education, are there certain areas of the state where those outreach efforts are going to be focused?
They're going to be focused in the major cities, in New Orleans, in Baton Rouge, Shreveport, Lafayette. You know, all of the major, the large cities of the state will get a heavy emphasis. You know, there's going to be a focus on voters who will be voting. I mean, obviously, in an election like what we're going to have this fall, it's going to be a low turnout election, so it's going to be important to get the information to the chronic voters, people who vote. As we know, these elections in Louisiana typically will be a low turnout election. Secretary of State, we only have one statewide race on the ballot. I don't know what the turnout will be. Some of you maybe have seen some figures on that. I'm thinking maybe 25%. If we get to 25% turnout, we'll be doing really, really well. So that's a really low turnout, which means that this message has to be targeted, it has to be effective, it has to inform the people that are going to vote. Yes, sir.
There's a wide range of political groups involved in this. Have you had any difficulty adapting your messaging to those different groups' interests?
No, absolutely not. It's been one of the most amazing experiences I personally have ever had, that I've had a chance to meet people from groups that I never would have ever associated with. As a conservative Republican, I mean, there are some meetings that I probably would never have been invited to. But in any event, it has been great to get to meet people from the other side of the political fence and work with them on this issue. It has brought together people from all points of the political spectrum. Liberals and conservatives have come together and said, look, this is right for Louisiana, and even though we might be in opposition on many, many issues, we are all together on this issue. And so that, to me, has been one of the greatest outcomes of this whole debate, is that we have people traditionally that support Democrats and those that traditionally support Republicans that have all come together and said this is about liberty and justice and fairness, and we all need to come together to pass this amendment. So I'll have to say the answer is no. It has created some interesting moments of meeting some people that some of us would never have met, but it's been great. It really has. Yes.
I'm curious, are you aware of any plans for polling on this issue?
Well, yes, there will be some polling on the issue. Okay, there was some polling that was done back in May, right after the legislature, that indicated some really good numbers. Let me see if I can find that for you. But yes, we do. There's polling. We do have some polling numbers, and we expect some more polling numbers. So I've got. There was a poll conducted on May 19th through the 22nd. That was commissioned by our coalition, and which indicated that the support for the amendment at that point was 50%, opposed was 28%, undecided was 22%. That was conducted May 19th through the 22nd. After some further questions to the respondents to the poll shifted to 56% in favor and 23% opposed, with 21% still undecided. So that was just a brief snapshot back in May, right after the legislature, to kind of get a feel for how people felt, and it was very, very positive. So, which indicates to us that if we can just engage in the education process of informing the public, that we should win this election. But there's a lot of hard work that needs to be done. Any more questions? Those are great. Those are great. Yes, sir, back there.
I think you mentioned that in 1973 there was an attempt to change the current law at that time to what you're trying to do now. Was that in the legislature or the Constitutional Convention?
That was in the 1973 Constitutional Convention. And an attorney from Alexandria was a delegate, Chris Roy Sr. He was a partner of Camille Gravel. It was Gravel, Roy, and Burns. Chris was a delegate from Alexandria. His son later served in the legislature, and his name was Chris too. But it's not the younger Chris. This is the old Chris. And Chris Roy's still alive. I think he's 84, 85 years old. And I talked to Chris Roy about this several months ago. And Chris tried on the floor of the Constitutional Convention to change the law, to go to unanimous juries. He was met with serious opposition. An attorney from Eunice by the name of Jack Burson was an assistant DA in St. Landry Parish, and he was a delegate. And so they had a really heated debate about this on the floor of the convention. And it ultimately failed, but a compromise was proposed. I think Walter Lanier from Thibodeau was involved in that. The compromise was proposed to go from 9 out of 12 to 10 out of 12. Now, what's interesting about all this is that took place in 1973. The previous year, we had the Apodaca versus Oregon decision, which is the decision of the U.S. Supreme Court, which was 4-1 to 4, okay? It's a really strange decision, but that's the decision of the U.S. Supreme Court that said unanimous juries were required in federal courts, but they were not required in state courts. So that's what's left us where we are today because of that decision in the Apodaca case. That happened in 1972. So the part of the discussion on the floor was, well, you know, the Supreme Court just ruled that this was constitutional. You know, do you think you're smarter than the Supreme Court? And, you know, well, I mean, you know, the Supreme Court ruled that it was okay. And so there was a lot of give and take about that. And, you know, I think that helped defeat the effort. But I'll have to say, Chris Roy of Alexandria tried in 1973 in the Constitutional Convention. It failed. But that's the only effort, Mr. Hightower, that I'm aware of where anyone ever tried to change it since 1880. Anything else? Yes, sir.
Mr. Bernhardt, the former owner of Shaw, said when you look at an analysis of where businesses decide to do business and settle, that they let the accountants make all the decisions, but then it comes down to individual decisions. This that you're mentioning, isn't it just a symptom of difficulties in the state of Louisiana? And after this item was passed, will you be involved in other issues that hold Louisiana back, or will this just be a one-time experience?
Well, I will do anything I can to help improve Louisiana. I live in Louisiana. I was born in Louisiana. I love Louisiana. And I think if God has placed us here, there must be a reason. And the reason is to do everything we can to try to improve our community and make our state a better place in which to live and raise our children and grandchildren. I'd love to have my children living in Louisiana instead of everybody moving to Texas, okay? So, but you know, right now, out-migration is a serious problem in Louisiana. So this law right here is something I believe that's held us back. I really do believe that. And you know, I think when the people vote for Amendment number 2 and pass Amendment number 2, I think it'll send a message to the whole nation that Louisiana has turned the corner, that Louisiana has gotten rid of the last vestige of the Jim Crow era that had remained on their books for all these many years. I think the eyes of the country are looking at us. I mean, the world is watching to see what we're going to do. And you know, you may be aware of the fact that this received national publicity during the session and after the session. And it'll continue to receive nationwide publicity. I believe we'll do the right thing. I hope we will, but I'm going to do everything in my power to see that we can pass this law. It'll make Louisiana better. And you know, look, who's to say there might be other issues that we can work on down the road. We'll just have to wait and see. But one thing's for sure, this is something we need to do now. And you know, by the way, the people can do that. This is the beauty of federalism. You know, we talk about federalism, and that's kind of an abstract subject. But if you like federalism, I mean, you know, if you like the Constitution, think about what federalism means. Federalism means that the states get to decide. And guess what? We can do this. We don't have to wait for the U.S. Supreme Court to do this for us. The citizens can take care of this. And I think that's the beauty about what Senator Morrell and Senator Claytor and Representative Mack did this summer is they moved forward. The legislature took a stand, and we sent a message out. You know what? Louisiana can take care of this. We don't need the U.S. Supreme Court.